A federal judge has ruled that Righthaven, the company that sues websites and blogs on behalf of the Review-Journal and the Denver Post, does not have legal standing to sue. And this past Monday, the same judge ruled that publishing an entire article without the copyright holder's permission, the very reason Righthaven has filed suit, is in fact legal in that case and a fair use of the work. Yet another Righthaven suit was dismissed today. Where does that leave Righthaven? And what about the more than 100 bloggers who forked over thousands of dollars in settlements already? Joining me to answer those questions and more, Righthaven's CEO, Steve Gibson. Welcome back to the program.
Pleasure to be here.
You really screwed this whole thing up, didn't you?
Not at all. I think you could, well, this is not sports and it's a lot more serious than sports. I think that you could look at this almost as halftime. There's been a lot of cases that Righthaven succeeded on in terms of the standing issue last year and somewhat into this year. The technical issues right now are very, very profound in terms of whether or not we have standing. The issues are really focused on whether presently a non-exclusive license granted to Stevens Media gives them standing or not. That issue really hasn't been addressed.
I understand that. We're going to get into that.
In some cases.
There are two issues here. There's the issue that you just mentioned, which is a technical issue, and then there's the issue of why you use the tactics that you did, which we talked about previously. First of all, let's look at what the federal judge, Roger Hunt, had to say about the argument that your agreement with Stevens Media gives you the right to sue. This conclusion is flagrantly false to the point that the claim is disingenuous, if not outright deceitful. The court believes that Righthaven has made multiple inaccurate and likely dishonest statements to the court. Now, I've read a lot of court documents, sir, and you've read even more. That's very harsh language for a judge to use about an attorney. He's talking about you.
Well, I'm not the attorney. I'm the CEO of the company.
That's your company, okay?
But let me respond
to that. The buck stops with you, does it not?
You're taking that a little bit out of context.
Oh, here we go.
The context is whether or not a particular disclosure with respect to a certificate of interested parties was giving the level of full disclosure that the court would like. We understand that these technical rules as to whether or not there was a direct or indirect payment that we've examined, the attorneys have examined, is whether or not that needed to be disclosed and whether or not Stevens Media needed to be more disclosed in terms of someone that was part of this litigation.
Mr. Gibson, this just sounds stupid to me. Everyone knew you were working for Stevens Media.
Well, I would not call Judge Hunt stupid.
He's not the one I'm calling stupid here, sir. You guys have a noble purpose here. Let me just say this. You have a noble purpose. I have a lot of content online. I want it protected. You know what I do. You went about this in the most ham-handed way. You didn't warn people. You know what this really seems to be about now that we know about this profit sharing?
Respond?
Yes. Do you know what I think this is really about? This was just a shakedown. That's all this was.
Absolutely not. Ever since the advent of the internet, the level of copyright infringement has ballooned. The purpose of this company and the intention of Stevens Media was not to do something shady. As you said, everyone knew that Stevens Media and Righthaven were in this together contractually. The first time I was on the program, you were not mystified with respect to that notion. The intention in the documentation is very, very clear that Stevens Media wants Righthaven to have standing with respect to the exclusive rights and the ability to go after infringers. Why would the judge
call you deceitful?
I think you're taking that out of context. He says there was potential disingenuousness.
Likely dishonest statements. Flagrant misrepresentations.
No,
those are his words, not mine.
You're taking that out of context with respect to
There's no good context for that.
No, the context is with respect to a specific document with respect to the certificate of interested parties, not with respect to the underlying contracts. I think that you need to look at that more closely in terms of the cases that are being filed. What's important to know here in terms of where Righthaven is at, is we're going to be able to provide future filings to the courts with respect to the fact that Righthaven is the only company that has standing at this time. Stevens Media only enjoys, and I know this is very, very complicated, a non-exclusive license. Let me just give you an analogy.
I'm going to let you respond, but you don't want to get lost in the legalese here. You'll never be able to make your case, and you just hear me just talking. That would be terrible if I was the only one talking. Be back with Steve Gibson of Righthaven when Face to Face returns, and later, Dan Hart's got two problematic clients at the same time. We'll talk to him about Byron Giorgio and Wade Wagner and what's going on in those cases when Face to Face returns. Welcome back across Nevada to Face to Face. A little later, we're going to talk about that U.S. Senate race and Harry Reid's effort to get Byron Giorgio out. What Byron Giorgio's political consultant. At first, it seemed like a good idea at the time, protecting online content. There's a lot of it. The RJ hired a company called Righthaven to do it. Now it's become a total mess for Stevens Media, which owns the RJ and Righthaven. Federal judge making all kinds of nasty comments. Steve Gibson is the CEO of Righthaven and says those nasty adjectives were taken out of context. All right.
You got to respect the judicial process, John. Okay, what the courts are doing.
You're the one who seems not to respect the judicial process. Your company.
Can I respond?
Wait a second.
Let me finish.
I want to read some of this commentary. Let me
finish my sentence.
I'm going to read this stuff.
The sentence I want to finish is that we are respecting the judicial process, and this is the way we're respecting the judicial process. The hardworking federal judges are saying this type of documentation needs to be enhanced. Now,
that's not what they're saying. They're saying you misled people.
That's absolutely wrong.
Deceitful, dishonest.
No, this was with respect to possible disingenuousness with respect to a certificate.
Possible disingenuousness.
With respect to
a certificate.
With respect to a certificate of interested parties, you're misreading the opinion, and you're mischaracterizing.
I read the entire opinion.
Well, then you should read it with respect to the standing question and a technical issue with respect to the certificate of interested parties. There's
you
a
can
lot
fix
of
that, right? You can fix that. You can by amending the contract, which you've already done. Correct.
With respect to additional disclosures on the certificate of interested parties. This is a minor issue with respect to the standing question, which is completely separate.
All right, let me show you. There are these groups that have gotten upset about the way you've done this, and they've gone after you. This gentleman from the Electronic Frontier Foundation, civil liberties group, called Righthaven's copyright ownership claims false. This is a blog post from Monday. In short, the assignment is a sham. Righthaven's claim has been baseless from the outset. Stevens Media, which has struggled to hold the litigation at arm's length, is the true and exclusive owner of the copyright and the only entity withstanding to bring a copyright claim. He's suing Righthaven.
And let me respond to that.
I'm going to, but I just want...
Well, let me respond one by one. The first, not many people in your audience maybe deal with copyrights on a daily basis. The analogy here is you can own a house and have title to that house, and then you can lease that house, allow someone to use that house. Allowing someone to use the house doesn't mean that you lose your title with respect to that house and being able to do certain things with that house. The debate that we're having is whether or not the documentation, where the clear intent of Stevens Media and Righthaven is to have Righthaven own the house, whether or not, in fact, that documentation at this point supports it.
Did you screw up this relationship? Is that what happened? And you
absolutely
got
not. Absolutely not.
But that's essentially what the judge said.
You have to respect we are respecting the judicial process.
You keep saying that.
We are. And we're absolutely convinced of the fact that the process will work itself out with respect to recognizing what level of documentation is required. I think part of what's happening here is that the federal judges recognize that, Righthaven has hired some of the top lawyers across the country, copyright lawyers, Harvard law professors, and they understand that we're affiliated with an organization as reputable as Stevens Media. I'm sure that you have a view of Stevens Media that may not be the same as mine.
I used to work for I used to work for the RJ.
But in any event,
protect me, right?
I think what the judges are saying is that, listen, folks, Righthaven is filing a lot of lawsuits. They understand that we're potentially genuine with respect to upholding copyrights. They don't want to see Righthaven competitors potentially come on with not solid documentation, and they're giving us guidance as to what the documentation should be.
What you've done, and we discussed this before, Mr. Gibson, is you've been swatting, using a sledgehammer to swat gnats. You've gone after all these non-entities who you couldn't possibly prove any damage to Stevens Media. Why have you done this?
You know better.
No, I don't.
You know better than what you're saying.
You filed hundreds of lawsuits.
Let me respond. A bunch, a whole wide range of people, including very, very powerful people and powerful organizations.
A few powerful, you're right, you're absolutely right.
Many.
But you've cat bloggers and others, come on.
How do you deal with an ocean of infringements? Who's going to staff sending out 1,000 or 1,000,000 cease and desist letters and try and follow that up?
You sue the oceans, not the puddles. That's what you've done.
No, but the ocean is composed of all of these thousands, if not millions, of infringers. And so for you to say that we should only be suing people that have a net worth of $1 million.
I didn't say that.
Well, that's what you're implying, that somehow is going to be a successful strategy. I would argue that the purpose of the deterrence in the Copyright Act is against anyone who posts the content on the internet. If you Google a search, Google doesn't say, oh, we're only going to show you the content if it's at a mega site. They're going to show you the content if it's topically
I understand.
relevant.
Well, we're almost
You
out of
understand
time.
this. Sure.
Stevens Media is still your client, right? They haven't fired you over this.
Stevens Media continues to be our business relationship, and
The 50-50 split and the profits.
and believes soundly in our perspective.
This is, as I said before, it's a noble cause to try to protect copyright.
With that
on the internet.
endorsement, I'm sure we'll be successful.
But what I'm saying is haven't you hurt the cause based on what Judge Hunt said in that document?
Talk to me when we're not at halftime.
You're saying you're going to continue to file these suits.
Well, we're going to continue to fight the standing battle, and then I believe that we will succeed ultimately in the standing battle, and then we will take it at another level.
So you're going to fix, what's essentially you're going to fix that you don't have standing
Well,
to sue.
don't forget, there's something called the Ninth Circuit Court of Appeals that will be able to look at these questions, and we're going to give the
You're going to the Ninth Circuit.
That's what I believe that my lawyers will be advising me.
All right. Well, look forward to that. I do appreciate your willingness to come back. I hope you come back after the Ninth Circuit. We'll talk about what happens there.
Thank you very much.
Steve Gibson, thanks for coming on. When we come back, another controversy. Byron Giorgio filed for the U.S. Senate. Now, Harry Reid doesn't want him to run, but Harry Reid appointed him to a big, important national commission. What's going on here? Dan Hart, a very experienced operative here, who's advising Byron Giorgio. We're here to talk about that, and Wade Wagner suing the North Las Vegas City Council. Back in a moment.